We'll continue the lecture of Partha 2, like Indian 2, because I've already said a few words about Partha in the last lecture series. I think it's better to switch over the mic to him.
I only hope my lecture part 2 is not as bad as Indian 2. Okay. Now, the last occasion I had taken you through the history of the whole concept of courts in India, and then the history of litigation qua land in India, how courts have evolved jurisdiction in personam, and how suits for land came to be introduced for the first time in 1862. And then I talked to you about the Specific Relief Act of 1877, the judgments rendered post 1862 till about 1950. And I stopped, I think, with Mulji Jaita of 1950. Now, one of my colleagues pointed out to me after listening to the lecture on YouTube, there's a factual error in one statement made by me. I'm duty bound to correct that. I had initially told you that 1862 was the first time when letters patent was issued in India. It's actually wrong. When the Supreme Court was established in India in 1774 for the first time in Bengal. There were three Supreme Courts, as I told you, 1774 in Bengal, 1800 in Chennai, and 1824 in Bombay. Those were the times when letters patent was issued for the first time, not in 1862. So letters patent came into force for the first time in India when Supreme Courts of Judicature were established. So that is the factual error which I wanted to correct at the outset itself. Now, as far as the present lecture goes, now I will be concentrating mainly on the so-called changes brought under the Specific Relief Act of 1963, and why those changes are not real changes but are illusory, and what continued from 1877 also continued in 1963, albeit with a little bit of additions and little bit of deletions. And interpretation of courts post 1963, which led to unsettling the law as settled in 1950 by Mulji Jaita, and 1929 Madras High Court full bench, and 1927 Bombay High Court 7-judge bench. So all three were sought to be totally unsettled because of introduction of the 1963 Specific Relief Act. Now, it would be my endeavor to point out to you and try to impress upon you that the 1963 Act did nothing extraordinary, warranting such a massive departure by courts in the three presidencies from the settled law as on 1950. Now, for that, you must first understand what happened under the 1877 Specific Relief Act. Now, there are three provisions of law under the 1877 Act which are important for understanding whether there was any change as such in the 1963 Act or not. Now, Section 5A of the 1877 Act read thus: specific relief is given by taking possession of certain property and delivering it to a claimant. That is Section 5. Section 12 says, unless the contract to the contrary is proved, court shall presume breach of a contract for transfer of immovable property cannot be adequately compensated by terms of money. Same as in the 63 Act. Then the Section 27 of the 1877 Act talked of enforcing a contract against third parties, subsequent purchasers. And that apart, there are two other very important provisions which have been considered by courts in India, including Supreme Court. One is Section 55 of the Transfer of Property Act, and also Order 21, Rule 32 of the CPC. Now, these two provisions were in existence even as on 1872 and 1908, as the case may be, continue to be in existence even today. Now, they are very important for this reason. Now, Section 55, more particularly 55(1)(f) reads thus. 55 talks of duties of a seller of property. It says, the seller is bound, F, to give on being so required the buyer or such person as he directs such possession of property as its nature admits. So, Section 55(1)(f) of the Transfer of Property Act talks of duty of a seller to deliver possession of the property to the buyer upon so being required. Now, section 54 is also important. If you people know section 54 by now, contracts for sale. It says no contracts for sale creates an interest in property. Now, you will have to read these two together because 54 says contract of sale creates no interest in property. 55 says upon being required by the buyer, a seller must give. So, when we talk of seller and buyer, it doesn't mean a contract of sale. In a contract of sale is a proposed seller, proposed buyer. It fructifies into a seller or a buyer only when a contract for sale is registered as a sale deed under the Registration Act. So, no title passes under section 54 in a mere contract. But under 55, when you talk of a duty of a seller to give possession to a buyer, it contemplates a situation where the contract of sale has fructified into a sale deed and has been registered under the relevant provisions of the Registration Act of 1907. So, and then one more provision which I said was important is Order 21 Rule 32.5 of the CPC, which is in existence even as on date. It says where a decree for specific performance of a contract has not been obeyed, the court may, in lieu and addition of all processes aforesaid, direct that all acts be done to ensure performance of that contract. So, in other words, when you file an execution petition today, you ask for if the defendant fails to execute the sale deed, what do you ask for in a suit for specific performance? Direct the court to execute the sale deed in favor of the successful plaintiff. And in an EP, you can also ask for possession. So, you can ask for sale deed to be executed by court in lieu of the defendant who is refusing to follow the decree, and also possession. So, these are the basic sections in the 1877 Act which you must keep in mind, in the back of your mind, before going into the 1963 Act. But as I said, even the 1877 regime did not make possession in favor of a successful plaintiff compulsory, because as I told you the other day, possession is inherent according to courts in every suit for specific performance. Unless you're already in possession, you don't need to ask for possession. See, what happens, as I told you the other day, I gave you an example. A enters into a contract with B for sale of his land, puts B in possession in part performance of the contract. B doesn't need to ask for possession because he's already in possession. B needs to ask for possession only when a person other than A is in possession, a third party is in possession, or in a joint property where you sue for partition and separate possession. Those are the instances when you need to ask for possession. But I'll tell you 3 examples of judgments from 1877 which dealt with this aspect of possession before going to the 1963 Specific Relief Act. Now, there is a 1916 Allahabad High Court judgment which says thus: a suit for specific performance of an agreement for sale will remain as such even if possession is sought for by the plaintiff by virtue of the obligations of the vendor contained in section 55(1)(f) of the Transfer of Property Act, which I just now told you. So, that's an inherent obligation. That law imposes that obligation upon all sellers to give possession. Whether you ask for it or don't ask for it, it doesn't change the nature or character of a suit. That's 1916 Allahabad. Then the Bombay High Court in 1925 held this: the right to demand possession by a purchaser arises only after a decree for specific relief is passed and a conveyance is executed, though for the sake of convenience and to avoid multiplicity of suits. No, please note this. For the sake of convenience and to avoid multiplicity of suits, it's open for the plaintiff to make a claim for possession in the same suit for specific performance. Now, this is in 1925, much before the 1963 Act came into force. Then the Madras High Court in 1923, ILR 47 Madras, held thus: a division bench speaking through 2 very learned judges, Justice Cheravur Krishnan and Justice Venkata Subba Rao, and I'll read each of their excerpts very briefly. Justice C. Krishnan said thus: the learned judge held that a prayer for possession in a suit for specific performance is a proper prayer without altering the character of the suit, and that merely because a prayer for possession is added in a suit for specific performance, the suit does not either become a suit for possession or become a combination of both suits and remains primarily one for specific performance alone. And Justice Venkata Subba Rao said thus: if a claim for possession is made in a suit for specific performance, it must be treated only as a suit for specific performance and it does not become a suit for possession. So, the idea behind all this was 55(1)(f) of the Transfer of Property Act was already there. You had to give possession whether you like it or not under law. So, you don't need to ask for it. You can, If the executing court felt at the time of executing the sale deed, possession also should be given to you, the executing court will give possession to you. As simple as that. Merely because you added the prayer for possession in your suit for specific performance, it did not change the nature or character of the suit. That was the consistent law. Now, Calcutta High Court in 1952, Calcutta, followed later in earlier judgments of Patna in 1925 and 1931, also held the same thing. Patna High Court took the same view. Nagpur High Court took the same view. So, in the light of the regime between 1877 and 1950, there are a couple of inescapable facts. One, specific performance is only a decree in personam. It's a decree against a person, not against a thing or against a property. One. And secondly, the effect of such a decree is only to enforce a personal obligation incurred by a defendant in a suit. It is not to transfer title to property. It is not to transfer possession of the property irrespective of a dehorse title or dehorse the suit for specific performance. In other words, it is not a possession independent of specific performance. That's what I told you the last time also. So, one, when your suit for specific performance is the primary prayer and your possession is an incidental prayer which cannot survive without the main prayer, it does not become a suit for land. It does not become a suit for possession. Secondly, if your suit for specific performance is dismissed, you cannot succeed in your incidental prayer for possession. So that is the test which the courts have always formed and adopted. So therefore, irrespective of whether you ask for possession in a suit for specific performance or not, it does not make it a suit for land. That was the view till Mulji Jaita in 1950. Now let's see the Specific Relief Act of 1963, what has changed. Now, there is one section which was incorporated in 1963, which seems to have, for lack of better phrase, let the bull into a china shop. Now, courts have gone berserk on interpreting this particular section and upsetting the apple cart from 1862 to 1950. Now, let's see what they are. Section 22 is a new section introduced in the 1963 Act. Now, it says, notwithstanding anything to the contrary contained in the Code of Civil Procedure, any person suing for specific performance may, in an appropriate case, ask for possession, partition, separate possession, all that is okay. But 22.2 says, no relief for possession can be granted unless it's been specifically claimed. So, this seems to have created a huge confusion in the mind of a lot of courts, thinking that this is something very new. For the first time in 1963, it's come into force. They are recognizing possession must be asked for. Therefore, if you ask for possession, it ceases to be a mere suit for specific performance. It becomes a suit for possession also. That is the fundamental error, in my most humble and respectful view, that most courts have fallen into post-1963. Now, the reason why I am saying this is, the Law Commission report, which led to the drafting of the 1963 Act, is very important. Now, that Law Commission report was headed by none other than MC Chagla, what's his name? First Attorney General for India, what's his name? MC Setalvad. It was headed by MC Setalvad and had its members as Nalhi Palkiwala and a few other big names. Now, the Law Commission, before the 1963 Act, said, hitherto, we are all aware of the regime from 1877 till 1950, that possession need not be asked for. But there has arisen some confusion, because for non-seeking of possession, some high courts have held EP court cannot grant it. Some high courts have held EP court itself can grant possession. Even though we have section 55 of the Transfer of Property Act, even though section 55 1F says it's a duty of a seller to give possession to a buyer when demanded, still some confusion persists. In order to avoid that confusion, in order to remove that confusion, and in order to avoid multiplicity of suits, why should you drive a person to file a separate suit for possession? Ask for the prayer in the suit for specific performance itself. We are suggesting that this be incorporated as a new section. That is the reason why section 22 came in. Now, the idea behind 22 is twofold. One, to avoid multiplicity of proceedings, and two, to enable a person to ask for an incidental relief along with the main relief itself. Hitherto, it was not compulsory. Now the Act says ask for it. If you don't ask for it, you will not get it. But just because the Act has said now, if you don't ask for it, you will not get it, does it change the nature of the suit? That's the question which I am going to answer today. does it change the nature of a suit from a suit for specific performance to a suit for possession? Because the Act says, Section 22 says, if you don't ask for possession, you will not get it. But the very same Section 22 also says you can ask for it at any stage. What does any stage means? Any stage means the suit. What is an appeal? What do you understand of appeal? What do you think an appeal is? It's a continuation of the suit. SLP, if it's dismissed, nothing happens. If SLP gets converted into a civil appeal, continuation of the appeal. Ultimately, what the Supreme Court or the High Court in appeal would decide is whether the decree passed by the lower court should be accepted or set aside. So it is a continuation of the original proceedings. Now, when it's a continuation of the original proceedings, suppose I failed to ask for it in the suit. Can I ask for it in the appeal? When the other side points out saying he is not asked for possession, can I amend my plaint in the appeal and ask for it? What's your answer? Can I be allowed to amend my plaint in the appeal? Any stage. Of course you can amend it. Can I be allowed to amend my appeal in the civil appeal stage before the Supreme Court? Of course, yes. That's what the section says, at any stage of the suit, which means till the suit reaches its logical conclusion, till it fructifies into a final decree, one way or the other. So, if that is the situation, if I can ask for this amendment anytime, suppose I don't ask for it in the original suit, I ask for it in Supreme Court. Does my suit for specific performance become a suit for possession in the Supreme Court? How incongruous? How silly can it be? Now, that the reason why I'm saying all this is just because you ask for possession at the highest court or an appellate court or wherever at a later stage, it doesn't convert your suit, which is otherwise a mere suit for specific performance, into a suit for possession. The addition of Section 22 in the Specific Relief Act was meant only for two things: to avoid multiplicity of proceedings, so that you don't go file another suit to seek possession. And two, you're allowed to raise that prayer, make that prayer in the same suit. So that is the only reason why 22 came in. But see what courts have now done after the 1963 amendment, 1963 Act. Now, Calcutta High Court in two judgments in 1963 and 1964 read the law correctly, read Mulji Jaita correctly, 29 Madras correctly, and said, listen, 63 Act doesn't say anything new. It only says avoid multiplicity, make the prayer here itself. It doesn't change the nature or character of the suit. Two division bench judgment in Calcutta, 63 and 64. Both those judgments are beautifully written, but nobody has quoted it thereafter, not even the Calcutta High Court. Those two judgments have been written in sand, totally forgotten and erased. But those two are division bench judgments followed later on by the Supreme Court in 2022. Supreme Court resurrects the whole thing in 2022, incidentally. And I'll tell you a brief story about that when I come to it. But 2022 now settles the law in favor of what I am trying to impress upon all of you now. Right? So now see what the courts have done. Now, after 1963, one of the most significant judgments of the Supreme Court, incidentally, is Babulal versus Hazarilal. It's a 1982 judgment, 82 1 SEC, page 525. It's one of the most significant judgments, which I feel has, if it was correctly followed till date, there will be no confusion at all. So, Babulal, and what happened in Babulal? There, the question in Babulal was, where a plaintiff did not seek for possession during the suit, will he be allowed to seek for possession during execution petition, while executing the decree? There, the court analyzed why Law Commission suggested Section 22, why Section 22 was enacted first of all. Is it a mere rule of pleading, or is it a substantive law which came into force for the first time in 1963? And if it is not something substantive, does it affect the nature or character of the suit? Supreme Court, in reaching this conclusion, has taken a consistent view after following 50 Federal Court, 29 Madras, and quoted virtually 30 judgments between 1877 and 1950 as to what that earlier regime was. And then see what they have held. I'll tell you a brief excerpt of what they have held. In cases where the contract between the plaintiff and the defendant, possession vests with a third party by means of a subsequent sale, a mere suit for specific performance by plaintiff will not be sufficient. He must also ask for possession, but that does not change the nature of the suit. 2. In cases where property is agreed to be conveyed as jointly held by the defendant and other persons, plaintiff must claim for partition and possession, not merely specific performance. Still doesn't change the character of the suit. In cases where defendant alone is in exclusive possession, then a mere decree for specific performance simpliciter would specifically give relief to the plaintiff. Now mark the words here, mere decree for specific performance. Now, why I am emphasizing this here is, if you straight away jump to 2023 Adcon, there the Supreme Court coins something called a mere suit for specific performance simpliciter. They have forgotten decree in Babulal. They coin a new word, suit simpliciter for specific performance. I'll come to that confusion and I deal with it. And why that judgment ought to be overruled very soon, hopefully. So, in cases where a defendant is exclusive possession, then a decree simpliciter for specific performance is enough because he is already in possession. Then it also held relief for possession need not be claimed in all suits for specific performance and needs to be sought on only in an appropriate case where the defendant requires. Read it with section 55 of the Transfer of Property Act. If defendant is already in possession, he doesn't require possession. If third party is in possession, plaintiff requires possession. If there's joint possession between co-owners, partition and separate possession. Only when it's required. Required means under law. Not because I want it or I don't want it. Not my personal subjective wish. It's an objective requirement. Right? So ultimately what Babulal held, the Supreme Court held, is that 22(2) provides for amendment of the plaintiff at any stage of the proceedings for including possession, and therefore section 22 is only an enabling provision. Please note that. What do you mean by enabling provision? It is not a substantive change. It is a mere procedural change. It is a mere enactment to help you people, help anybody coming to court and fructifying a decree to its natural consequence. It is not something which is created for the first time as a substantive law, for it to be reinterpreted in 40 judgments thereafter. No, totally uncalled for. Now, post Babulal, let's see how the courts have interpreted. Calcutta High Court, a 3 judges bench, a full bench of the Calcutta High Court in 83 Calcutta says thus: Section 22 of the Specific Relief Act has not brought about any material change in the substantive law relating to grant of possessory relief in a suit for specific performance of an agreement to transfer immovable property. That's the correct view. Then they also say this: reliefs by way of delivery of possession or partition and separate possession are ancillary and consequential to the passing of a decree for specific performance of a contract to transfer immovable property. Rightly so. And then, when a plaintiff has not yet acquired title, the vendee's claim for possession is derived from and founded upon the agreement which is specifically enforced. Thus, possessory reliefs mentioned are dependent upon and flows from the decree of specific performance. Exactly what I told you the previous lecture. Your relief for possession is completely dependent upon the first prayer for specific performance and not independent of it. The moment it is dependent, it is not a suit for possession, merely because you add that prayer. So that is the Calcutta High Court, a full bench. The same view has been adopted by 2 other division benches in the Calcutta High Court in 83 Calcutta and 92 Calcutta. Now come to Madras High Court. This is where the deviation for the first time occurs. Ram Bahadur Thakur, 89-2 Law Weekly 529. Justice M. Srinivasan's judgment. There, the question was whether a leave granted to a plaintiff for maintaining a suit for specific performance of a property situated outside Madras High Court limits should be revoked or not. On 2 grounds. They said, 1, you are asking for possession in the suit, and 2, the property is outside. And there is a sale deed pending suit transferring the property to a third party. Therefore, you will be divesting the third party of title and it becomes a title suit. So, on these 2 grounds, Justice M. Srinivasan revoked the leave, saying it is a suit for land. Now, while coming to a conclusion that it's a suit for land, I'll just give you 5 main reasons why the learned judge has held so, and why all 5 reasons are patently wrong. Now, 1, he says this: every suit for specific performance is also a suit for recovery of possession after passing of the 1963 Specific Relief Act because of Section 22. This is first observation. Second, none of the decisions under the 1877 Specific Relief Act can be relied upon because the position has completely changed after 1963. Second reason. 3, all judges of Mulji Jaita were unanimous of the view that a suit for possession will be a suit for land. Third reason. Fourth, the proper form of a decree in that suit, divest third party of title and vest title in favor of the plaintiff, will involve divesting somebody else of their title. Therefore, form of the decree will determine the character of the suit. That's fourth reason. And fifth reason, 1929 Madras 5-judge bench, which we discussed the last time, cannot be considered good law anymore because of the 1963 Specific Relief Act. These are the 5 reasons given by the learned judge to hold that leave should be revoked. That is a suit for land, because it's a suit for land. Now, I'll tell you why all 5 reasons are patently and latently erroneous. Now, one, on every suit for specific relief becoming suit for possession, Babulal never held so. 1877 to 1950 law was very clear. It is only an incidental relief. Babulal never interfered with that view. In fact, Babulal of 82 Supreme Court, Babulal clearly says, after referring to 30 judgments from the old 1877 Act, it is not a suit for possession. Possession is only incidental. It is not the main prayer, because it's dependent upon the prayer for specific performance. Secondly, you all heard me saying Babulal has clearly held 22 is only a rule of pleading. It is only to avoid multiplicity of proceedings. There is no reason to hold after 63 everything is changed. Absolutely no reason. Now, the other reason given by the judge that 1877 Act is totally revamped. 1963 creates new rights. Again, falls to the ground. If you see the Law Commission report, if you see Babulal itself, purely procedural, nothing substantive. If it's purely procedural, nothing substantive, there is no reason for this for the learned judge to have held that 63 Act changed everything. It changed nothing. It only made it easier for a plaintiff to claim for possession in the same suit. Hitherto was not compulsory. Led to a lot of confusion between courts. Then, on the form of a decree divesting a third party, changing the character of the suit, I have not seen a single judgment till date apart from Ram Bahadur Thakur which holds so. A form of a decree can never be determinative of the character of the suit. You saw in Mulji Jeta 5 judges bench, it says dominant purpose of the suit determines the character of the suit, not even your prayer. If prayer cannot determine the character of the suit, I fail to see how form of a decree can determine the character of a suit. A decree is something which is drafted based on a judgment. Now, if the judgment itself rendered by a court does not change the character of the suit because the primary object, the judgment to discuss the primary object of your suit, if that is different from suit for land, namely possession or title, it does not become a suit for land, otherwise merely because you incidentally claim possession of property. Therefore, form of decree determining the character of the suit, unheard of, totally erroneous. And then the other reason given by the judge is, if you say, let's see, suit for specific performance simpliciter without asking for possession. Let's take a simple example where the defendant is, plaintiff is already in possession, in part performance of the contract. Plaintiff sues for specific performance of the contract. Now, what happens if a decree is passed? The defendant refuses to obey, EP is filed. What happens in the EP court? I ask the sale deed to be executed. What happens on execution of sale deed? I become the title holder. Going by this logic, form of decree determines the character of suit. Every suit for specific performance, whether you ask for possession or not, results in change of title from A to B, and therefore will become a title suit. I'm sorry. That can never be the reason. The form of a decree is immaterial. The primary object of the suit is what is material. And then the last reasoning given by the judge that 1929 Madras 5 judges bench is no longer good law because of 1963 Specific Relief Act falls to the ground. Nothing has changed between 1877 and 1963 except for 22, including the fact that you can ask for a prayer for possession in the same suit as a suit for specific performance. Nothing has happened and nothing has changed. It only says if you don't ask for it, you can't get it, but you can amend it anytime. And courts have gone to the extent of saying, forget amending it anytime till the appeal. You can even ask for it in the EP, even if you have not amended the suit, and ask for amendment of the plaint in the EP. And the EP court has a right to amend the suit. That is the extent to which Babulal has gone to. That was a question answered in Babulal itself. If that be so, there is no reason for the learned judge to have held 29 Madras 5 judges is no longer good law because of 1963 Specific Relief Act. Because nothing substantive changed in this 63 Act. Now, post Justice Srinivasan's judgment, what happened is this very judgment in Ram Bahadur Thakur went on appeal to a division bench, and the division bench in 1998 did not interfere with that judgment. It said, I am dismissing the appeal for other reasons. But very interestingly, one of the judges who was the author of that judgment, Justice Sivaraj V. Patil, was also an author of another judgment in 1997 rendered immediately after Ram Bahadur Thakur. Now, his observations in 1997 Law Weekly, 3 Law Weekly, that's N. Dhanalakshmi versus V.S. Ekanathan, is very telling. These are his observations. Inclusion or absence of a prayer is not decisive of the nature of the suit. Exactly what I told you. Nor is the order in which the prayers are arrayed in the plaint, that the object of the suit has to be gathered from the averments in the plaint. That's first. Ram Bahadur Thakur should not be taken as a precedent. It's only governing the facts of that case. So, Justice M. Srinivasan's judgment set out not by the division bench, though not in direct appeal. In the direct appeal, they dismiss the appeal. In another matter, they say that should not be treated as precedent. So, and lastly, what the division bench says, Justice Sivaraj Patil's judgment in the division bench says is, in that particular case, possession is not asked for. Therefore, we are not going to the question whether it becomes a suit for land or not. If possession is asked for, maybe the result would have been different. Now, I would say the result can never be different just because you ask for possession. Right. Then comes the next major development, Adcon Electronics. The very oft-quoted judgment of the Supreme Court in 2001, 7 SEC, page 688. A division bench of the Supreme Court was dealing with a question as to whether a suit for specific performance without asking for a prayer for possession is a suit for land or not. Now, I can keep repeating it ad nauseum. Even if you ask for a prayer for possession, it doesn't make it a suit for land. That is the law, at least till Babulal in 1982 Supreme Court. So, when the Supreme Court started asking itself a question, is this a suit for land or not? In fact, my respected senior would always say, Mr.R.Parthasarathy, you ask yourself a wrong question, you'll always get a wrong answer. Question should be right first. So, the question before the Supreme Court was, is a suit for specific performance simpliciter a suit for land or not? That's a wrong question. The question should have been, what is a suit for land? If you asked yourself what a suit for land was, your probably answer would have been from 1877 to 1950 and 1982, Babulal. A suit for land is only when you ask for title to be decided, when you require possession independent of anything else, or when you want to protect your possession. These are the 3 instances. Nothing else is a suit for land. So, instead of asking the question, what is a suit for land? Question framed is a suit for specific performance simpliciter a suit for land? Without possession. So, obviously a long question will lead to a wrong answer. But mind you, if you remember right, I told you in Babulal, that is 82 Supreme Court, the question there was, is a decree for specific performance simpliciter enough to satisfy the plaintiff? The court never put a question as to whether a suit simpliciter for specific performance is enough. Decree. Is a decree for specific performance sale deed being executed enough or not? If not, what else is required? Put the man in possession or put the person in possession. So, instead of asking a question as to what is a suit for land, the Supreme Court went on a tangent and said, is a suit for specific performance simpliciter a suit for land? Which means the moment you ask for possession is not a suit for land. So, that is the major confusion which happened in 2001, which led every court in India into a tizzy, complete tizzy. And applying law, reapplying law, Adcon, before Adcon and after Adcon, the way they wanted to. Because according to me, the settled law as on 1950, reiterated further in 1982 Supreme Court Babulal, was unsettled in Adcon. Now, worst comes the next. Adcon did not even consider 50 federal court. Adcon did not even consider 29 Madras. So, the worst thing is Adcon not only put the wrong question, but then I should be emboldened to say that Babulal was Adcon considered both 50 federal court and 29 Madras. Babulal, the most important judgment post 1963, 82 Supreme Court, was not considered by Adcon. Babulal is the one which said 63 Specific Relief Act did not do anything drastic. It is just a amendment to the existing law which brought about a new rule, not a new substantive law, a new procedural law. Babulal is not even noticed in Adcon. Adcon goes by Mulji Jayata 1950 Supreme Court, but with a twist there. Adcon quotes the minority judgment in Mulji Jayata and says, we agree with that. Now, you should all know by now, under the Constitution, you have an article called 374. What does Article 374 say? Article 374 says that you have something called federal court in India, which was abolished in 1950. But all judgments rendered by the federal court will be binding on all courts in India till specifically overruled. That is Article 374. Now, they don't notice Article 374. They say, Mulji Jaita is a 5-judge bench. 3 judges hold it is not a suit for land. In personam jurisdiction has to be invoked and seen. And secondly, merely adding a prayer for possession will not make it a suit for land. They forget all that. They quote the minority judgment of Mahajanjay and say, we agree with that. Where Mahajanjay says that moment you ask for possession, it becomes a suit for land. So see the incongruence here. Somebody should have brought it to the notice of the Honorable Supreme Court. If Babulal was brought to their notice, or if the fact that you're referring to a minority view was brought to their notice, things would have been different. And I probably won't be standing here at all. But then, thankfully that happened, and I got an opportunity to read all this and also share my views with you. But what is shocking is Babulal is not noticed in Adcon. And Adcon goes on to hold, if you don't ask for possession, if the suit is only for specific performance simpliciter, it is not a suit for land. Conversely, it means if you ask for possession, it becomes a suit for land. So, this is the problem with Adcon. Wrong question leading to a wrong answer. Minority view in Mulji Jaita quoted as the correct law. And 374 of the Constitution ignored completely. Right. Then 15 years later, in 2015, there was another opportunity to the Supreme Court. Supreme Court had a fantastic opportunity to relook at the whole law in Excel Dealcom case. There the issue was whether a sale under Surface Act of an immovable property would amount to a suit for land. At least then they could have asked the question, what is a suit for land? Let's examine the whole thing. No. They don't notice Babulal again. They blindly go by Adcon and say, in Adcon it's been held that if you don't ask for possession, it's not a suit for land. In this case, Excel Dealcom, the agreement says the other party must be put in possession. The moment there's a clause there, it becomes a suit for land. So see the confusion, a new confusion created, a new category of suits created. What is a new category? If the agreement contains words to be put in possession, it becomes a suit for land. Law never requires that. Law 55 of the Transfer of Property Act makes it mandatory for every seller to give the buyer possession. Why should you put it there? Suppose by mistake I put it there. Does it change the character of a suit? Answer is absolutely no. So, in Excel Dealcom, Adcon creates one confusion by saying simpliciter suit for specific performance. Excel Dealcom confounds that confusion by saying the moment there is a clause in the deed, sale agreement or in whatever order of court that put the party in possession, it becomes a suit for possession. So between Adcon and Excel Dealcom, you had a number of other judgments which I'll just take you through very briefly. And post Excel Dealcom also, the Bombay and Calcutta High Court safely follow Adcon. Very safely they say, Adcon says so, therefore the moment you ask for possession, it becomes a suit for land. Madras goes 8 steps further and lays down various guidelines, and I'll come to that in a bit. So now in the interregnum between Adcon and Excel Dealcom, what were the cases decided by the 3 high courts? I'll just very briefly point that out to you. Bombay High Court in 2009 clearly held that where there is a suit for specific performance, if there is a prayer for possession made, it automatically becomes a suit for land. Therefore, you have to see whether possession is asked for or not. I am following Adcon. Right. So, 3 judgments of the Bombay High Court did that. Now, Calcutta High Court applied the same Adcon test, no change. Except for one judgment in Excel Dealcom itself. Excel Dealcom arose from Calcutta High Court. Excel Dealcom, Calcutta High Court wrote a beautiful judgment saying it is not a suit for land. Supreme Court reverses it in Excel Dealcom Supreme Court and says no, it is a suit for land because there is a clause which says possession must be given to you by court or by the other party. Right. Now come to Madras. Now there are 2 categories of cases in Madras, post-Adcon and also post-Excel Dealcom. One category of case relies on Adcon fully and says the moment you ask for possession, suit for land. The other categories of cases relies on Babulal and says Babulal holds that every suit for specific performance is also a suit for land because possession is inherent. So, the more I tried to read all this, the more confused I got. So, 2 views of the Madras High Court. One view says, Adcon follow blindly. Moment you ask for possession, it becomes a suit for land. Another view is, take Babulal, Also take Adcon. Babulal says every suit for specific performance inheres in itself possession. Therefore, every suit for specific performance, whether you ask for possession or not, becomes a suit for land. Now, see the consequence of that. So, 2002 Madras, a division bench, follows Adcon. The moment you ask for possession, becomes a suit for land. 2006 Tamarabarani Investments is a very important judgment for various reasons. 2006 1 CTC, a division bench chaired by Justice A.P. Shah, Chief Justice A.P. Shah, held two things. One, there were three prayers there. Suit for specific performance, suit for an injunction restraining the defendant from interfering with the plaintiff's possession, suit for an injunction restraining the defendant from alienating or encumbering the suit property. So in the first prayer, suit for specific performance, the court following Adcon said it's a simpliciter suit for specific performance, no suit for land. In the third prayer, the court held that where you ask for an injunction restraining alienation or encumbering, it is not a suit for land because you are not deciding title, you are not asking for possession. But the second prayer, the court held, it is a suit for land. You either give up that prayer or we'll send the suit out of Madras High Court. The plaintiff gave up that prayer, obviously under pressure from court for dismissal of the suit. We all know how it works in court. We have to think on our legs. So, Tamarabarani Investments held that the moment you ask for protection of your possession, it becomes a suit for land. Absolutely right. When a prayer in a suit is to protect your possession, irrespective of suit for specific performance, irrespective of encumbrance, etc., it is a standalone suit for possession. It is a suit for land. The court was absolutely right in saying unless you give up prayer B, we will send the suit out. So the plaintiff gave up prayer B, the suit was retained here. The court held that prayer A and prayer C is not a suit for specific performance because it's a suit for, not a suit for land, sorry. Because it's a suit for specific performance, simpliciter, and it's only for injunction restraining alienation encumbrance. Now I ask myself a question. While reading this, initially I was very impressed with this judgment and found no fault with it. But then on a slightly lateral thinking, have you people come across sections 37, 38 and 39 of the Specific Relief Act? Do you know what injunctions are? What are injunctions? When does a court grant an injunction? What is it directed against? Who is it directed against? Person. An injunction is always in personam. So a relief, see, you have a relief of permanent injunction under Specific Relief Act 37 to 39. You have a relief of mandatory injunction. You have a relief of temporary injunction where Order 39 rules 1 and 2 kick in of CPC. So in all three cases of injunction, the direction by the court is against a person. So if in a suit for injunction restraining alienation, I am saying you don't sell. You don't make it a suit for land because no title, no possession is involved. In an injunction prayer against protecting my, interfering with my possession, what do you say? You don't interfere. So how does it make it a suit for land? So prayer B in the Tamarabarani should also not be a suit for land, going by the plain definition of injunction. But that's where the caveat comes. Prayer B in Tamarabarani is independent of prayer A and prayer C. Prayer B in Tamarabarani is because the defendant is already, so a plaintiff is already in possession, independent of the contract, as a tenant, in some other capacity. So I'm already in possession, don't disturb my possession. That had nothing to do with the prayer for specific performance. That is why it's held as a suit for land. If your prayer for possession is under the contract of specific performance itself, in my view, it will not become a suit for land. So Tamarabarani ought to be read along with sections 37 to 39 of the Specific Relief Act, which defines injunctions as being directed against the person and not against the property. Please bear that in mind. Right. Now, there's another judgment which is of importance. A.C. Subba Reddy, 2008, a division bench of Madras High Court. There again they have said, following Tamarabarani, specific performance simpliciter, no problem. But then they also say that apart from title and possession, making it a suit for land, we will have to look into the prayer. That's where my problem comes. Prayer is immaterial. It's a dominant purpose object of the suit. So each judgment in its own way has contributed to the confusion. And it's not made life for anybody easy, especially for the judges themselves, because a single judge is obviously bound by a division bench judgment. Another division bench is obviously bound by the previous division bench judgment till judicial committee demands that they don't disagree. They send it to the Chief Justice to constitute a larger bench to decide that issue. So it's all a problem for all times to come, unless this is finally settled, which it still hasn't. But thankfully in 2022 it has, and I'll come to that. Now 2008, 2009, 2011, they all, in fact 2011 there's a judgment of a division bench of Madras High Court where the question there was charge over machinery. Machinery situate outside Madras. Will this amount to a suit for land? Now, we are talking of huge machineries embedded to the earth. Now, what do you understand by the word immovable property? Let me try and understand what you people understand of the word immovable property. Does it mean only land? Does it mean a building on the land? Fixtures, furniture. What about massive machineries embedded in the land? Does it become immovable? Okay, you know the law. I'm asking them. Does it become immovable? Machinery. You can dismantle a machinery and take it off, but does it become immovable? As long as it's embedded to the earth, it is immovable. So the question here was charge over machineries, whether it converts it into a suit for land. The court held it is a suit for land. Erroneously, because be it a mortgage of immovable or a charge of movables or a charge over machinery, what you are creating is a security over the property, not handing over the property itself. As I told you the other day, if an unsuccessful plaintiff is not paid the charge, his charge is not satisfied or the mortgage is not satisfied, he goes to court and asks what? Sell and give me the money. He doesn't say sell, give me that property. So money is the dominant purpose. That has been ignored completely in this judgment. And then 2012, 2014, you have a series of judgments. Now all those judgments which I referred to till now were relying on Adcon. Now comes the more confusing part, judgments which rely on Babulal, 82 Supreme Court, which said 63 specific relief act is not a substantive change. Right. Now, one of the first judgments which referred to Babulal is Justice Ramasubramaniam when he was sitting here in 2008 4 CTC. There he quotes Babulal, refers to section 55 of the Transfer of Property Act, 55 1F, and says it is not correct to hold relief for possessions inheres in every suit for specific performance because section 55 1F uses the word possession to be given if the other party chooses to ask for it. So learned judge interpreted that as meaning if a plaintiff asks for possession, only then you should give possession. If the plaintiff doesn't ask for possession, you don't need to give him possession. Therefore, all suits for specific relief are not suits for land. But my problem starts there. My problem is that whether you ask for possession or not, 55 mandates possession to be given. But in what cases? 55 talks of when the defendant requires only, in my view, only in two cases. One, when the defendant is not in possession. When the plaintiff is in possession. Sorry, when the plaintiff is not in possession, when the defendant is in possession. The other way around, sorry. The plaintiff in a suit for specific performance is the agreement holder. The defendant is the owner. So if the owner is in possession and the plaintiff does not have possession, he asks for possession. The second is when a third party is in possession. He asks for possession. Third is when there is a sale by an undivided co-owner to a third party. The third party asks for partition and possession. You can ask for possession straight away without partition. So in these three cases, section 55 itself recognizes inherently that you should ask for possession. Whereas if you're already in possession, you don't need to ask for possession. So that is where I don't agree with Justice Ramasubramaniam's judgment when he says the relief of possession doesn't inhere in all suits because a defendant need not ask for it. It's left to his choice. It's not left to his choice. Law compels him to ask for it if he doesn't have it. The only reason why he doesn't ask for it is when he's already in possession. In part performance or as a tenant. Suppose landlord sells the property to tenant. Tenant is already in possession. Why should he ask for possession? Suppose A agrees with B to sell his property, takes 75% advance, puts him in possession. Already in possession. So in those two instances, I don't need to ask for possession. The other cases, I have to ask for possession. Otherwise, I will not get possession because of section 22 of the 1963 Act till I ask for it. But I can ask for it at any stage, even an EP stage. So just because 55 says gives you an option to ask or not, the option is illusory. It is not a real option in my submission. It's an illusory option because if you don't have it, you have to ask for it. If you don't ask for it, you will not get it. As simple as that. Then comes a 2012 judgment which goes to the other end of the spectrum. Justice Ramanathan in 2012 reads Babulal and says, Babulal has held possession inheres in all specific performance suits. Therefore, every suit for specific performance, whether you ask for possession or not, becomes a suit for land by virtue of Babulal. So this is the other extreme. Justice Ramasubramaniam says, no possession unless you ask for, but you ask for it, it will become a suit for land. Following Adcon, following Babulal. Justice Ramanathan says, the moment you file a suit for specific performance, I am not concerned whether you ask for possession or not. Possession inheres in every suit because of section 55. The moment possession inheres in every suit for specific relief, I deem it to be a suit for land. Then what is the purpose of this fertile ground from 1877 to 1950? When all of them said, if possession is ancillary or incidental to your main relief, it does not change the nature or character of the suit. So all that is gone for a 6. So you have Ram Bahadur Thakur of Justice Srinivasan. Division bench says that is not to be treated as precedent, but creates its own confusion by saying if you ask for possession, maybe it will become a suit for land. Then you have a whole line of judgments between Adcon and Excel Dealcom which say, following Adcon, the moment you ask for possession, suit for land. Excel Dealcom creates a confusion and says, the moment you don't need to ask for possession. If your contract contains the word to be put in possession, it's a suit for land. And then you have all these judgments. 2012, Justice Ramanathan who says, you don't need to ask for anything. You file a suit for specific performance, simpliciter. Justice Ramanathan says, Adcon did not notice Babulal. I am following Babulal. Now see where the confusion is, or where the confusion is not. It's there everywhere. So there are 2 judgments of Justice Ramanathan in 2014 itself. Both judgments hold the moment you file a suit for specific relief, it becomes a suit for land, which is, in my respectful submission, completely erroneous. Then, what happens after Excel Dealcom? All this Excel Dealcom is 2015. We saw judgments till 2015. What happens after Excel Dealcom? Madras High Court follows both Adcon and Excel Dealcom and says, you ask for possession, it's suit for land. The moment there is a clause in the contract, it's a suit for land. Very simple. Just follow Supreme Court. Right? That happens in 2017, 2018, 2019. And then, finally, the nail in the coffin are 2 judgments of the division bench of the Madras High Court, rendered within a gap of 13 days, both by the same bench. Now, the first judgment is Raja Holdings, which is rendered by a bench, and within 13 days, another judgment, Harsha Estates. Now, these 2 judgments, I'll just very briefly tell you what they are and why I don't agree with them. I can't obviously overrule a division bench judgment. So, Raja Holdings was an instance where the issue was whether a suit for bare injunction. See, now this is not a suit for specific performance. Suit for bare injunction, restraining the defendants from alienating or encumbering the suit property. That's all. That's a prayer. The court held. Now, pausing here for a moment, I need to also tell you, there were 2 earlier division bench judgments, 2 earlier division bench judgments of the Madras High Court, one in 1997 and one in 2008, which says, a mere prayer for injunction restraining alienation is not a suit for land. Right? Yeah, it is not a suit for land because no title is involved, no possession is involved. You are personally injuncting a person from transferring. That's all. So that one is a 1997 division bench, 1997 3 Law Weekly, page 398. The other is 2008 4 CTC 160. Both division benches. The Raja Holdings division bench ignores those 2 division benches and says, or distinguishes them by saying, in those 2 cases, the primary relief was specific performance. This is an ancillary relief. In our case, the primary relief itself is suit for injunction. Therefore, we are not bound by those 2 judgments. Now, in my view, it doesn't make a difference whether it's a primary prayer or an ancillary prayer. As long as your injunction is not directed against protecting your possession or transfer of title or transfer of possession. The moment you ask for an injunction, it becomes personal. there is in personam jurisdiction exercised by court. And even otherwise, those two division benches have held, this does not make it a suit for land. However, in spite of those two division benches, Raja Holding holds, the moment you ask for an injunction restraining alienation and encumbrance of the suit property, which is an immovable property, we will hold it's a suit for land. Now the reason, I don't know the reason why the bench held so, but I can only visualize that the arguments in the next judgment concluded even before this judgment. They were preparing for the next judgment, which was delivered within 13 days. And that other judgment is Harsha Estates. Now that is reported in 2018, 3 Law Weekly, page 900. Now this is what the division bench holds in Harsha Estates. I'll give you what their judgment, what their exact words are in the judgment. They have categorized the suit into some 8 or 9 categories and given you an answer for which category is a suit for land, which category is not a suit for land. 1. If in a suit the relief claimed, if granted, would directly affect title to or possession of land, it will be a suit for land. No quarrel. So the moment there is a title relief claimed, or if possession is claimed in the suit, independent of the suit for specific relief, it becomes a suit for land. No issues at all. Fully agree with that. 2. If the object of the suit is something different, but involves consideration of question of title indirectly, then also it will become a suit for land. In my view, wrong observation. Incidental observations can never be the primary relief. Mulji Jayata, 1950 Federal Court. And all judgments before that and after that also. Incidental prayers cannot determine the nature and character of the suit. Your primary prayer is what is important. Because incidental prayers cannot stand independent of the primary prayers. So, observation number 2, highly doubtful. 3. A suit where claim is for recovery of possession or control over land will be a suit for land. No quarrel? Absolutely yes. Then 4. In a suit where determination of any right or interest over an immovable property is involved, it will be a suit for land. Any right or interest. Mortgage suit is an interest. What is a mortgage? Interest created over immovable property to secure a debt. It's an interest. Sale agreement is an interest. Especially sale agreements coupled with interest. Power of attorney coupled with interest. Say, what people all by now will be very familiar with the concept of development agreements, where the landowner engages a developer to develop his property, gives a power. By virtue of the power holder, the developer develops the property, gives the landowner 50% or 60% or 40% as agreed upon, sells or markets the balance. That is a power coupled with interest. So that is an interest in property. So the question there was, the fourth condition laid there is, the moment there is a determination of a right or interest over immovable property, it becomes a suit for land. I cannot agree to that, subscribe to this very broad proposition. Any interest is what Calcutta initially started, watered down and said, no, dominant purpose. Madras initially started in 1862, watered down in 1927 and said, dominant purpose, not everything. Bombay always held the middle path. Though it went to another extreme and this extreme, where it said suit for possession is only suit for a land, no other suit. But then they came back to dominant purpose. So all of them agreed on dominant purpose, ratified by 29 Madras, ratified by 50 Federal Court and 27 Bombay, 7 judges bench. In spite of all this to say, and in fact Mulji Jayata itself says that you should go by dominant purpose. Not every suit for anything incidental relating to land will not become a suit for land. Is a specific observation in Mulji Jayata. If that is so, till it is overruled by a larger bench of the Supreme Court, probably in a 7 judges bench, that is the law under Article 374 of the Constitution of India. So that was binding on Harsha Estates definitely, if not anything else. Then a suit for bare injunction restraining defendant from interfering with the possession and enjoyment of the property by the plaintiff. Yes, it's a suit for land. A suit for bare injunction standing on its own. Of course, it will become a suit for land because plaintiff is seeking to protect his possession. Then, in a suit for bare injunction where the plaintiff seeks to restrain defendant from encumbering or dealing with the property, by virtue of Raja holdings, we hold that it's a suit for land. They follow their own judgment, obviously. In a suit for specific performance of an agreement for sale, where relief of delivery of possession has been specifically claimed, it will become a suit for land. Again, contrary to Babulal, contrary to all earlier judgments. Then, in a suit for specific performance, where the suit is only for enforcement of the agreement simpliciter, note this here, where the suit is only for enforcement of agreement simpliciter, without seeking for any other relief, the same will also fall under suit for land because of the fact that every prayer for possession is inherent in a suit for specific performance under section 22 of this 1963 Act, read with Babulal. So whether you ask for possession or not, it becomes suit for land. And then in a suit for specific performance where the suit is only for enforcement of the agreement simpliciter and the plaintiff claims to be in possession, then it is not a suit for land, because you're not asking for possession. I do not know how that is an exception at all, but then they've carved it out as an exception. Then finally, apart from seeking to enforce the agreement, if you also seek injunction against the defendant not to interfere with your possession or not to create a charge or encumbrance, then also it becomes a suit for land. So they formed about 9 yardsticks to hold it's a suit for land. Virtually any suit is a suit for land the moment it is specific relief. So that is the import and purport of Harsha Estates. Now, in my view, there is no quarrel with the first proposition, third and the fifth proposition, which I already said we have no quarrel with. Now, insofar as para 10.2 is concerned, where 10.2 is what? 10.2 is, if the object of the suit is anything to do with immovable property, it becomes a suit for land. Moolji Jeta itself says don't fall into the trap. If the object of the suit is not anything but predominantly immovable property, title or possession, then it becomes a suit for land. Likewise, if you see, the Harsha Estates also goes to the extent of saying that if the defendant in such a suit takes a plea disputing possession of the plaintiff, it becomes a suit for land after such a plea is taken by the defendant. Now, it is unknown to jurisprudence till now that a suit is determined by what defense taken by a defendant. You all would have seen Order 7, Rule 11 of the CPC. Reject the plaint based only on the plaint averments. Why so? What the plaint says is the cause of action is what the court should determine whether it's correct or not what the defendant says. What the defendant says would be relevant after trial, not for rejecting the plaint. Similarly, if a plaintiff comes to court on a basis of suit for specific performance, you should go by the plaint averments. If the defendant disputes the plaintiff's right to possession, it does not convert that suit into a suit for specific performance. Now that's what Harsha Estate holds, saying the moment defendant takes that stand in his application to revoke the leave or in his counter, it is disputed question, therefore a suit for land. That can never be the determining factor. Harsha Estates, Justice M.M. Sundaresh and Justice Anand Venkatesh. So, after all this, now after Harsha Estates, I had an opportunity of appearing before another division bench within 6 months or so, and I tried to implore their lordships to refer this to a larger bench, saying Harsha Estates is wrongly decided. These are all judgments which have not been considered. The division bench agreed with me and with a smile said, we agree with you entirely, but we also agree with Harsha Estates. We're dismissing your appeal. So there ended my pursuit. But then, thanks to COVID, I got this opportunity of going through all this and voicing my concern about why so much of confusion is arising even after 1950, even after 1963 being held by Babulal in 82, that it's merely clarificatory, merely to avoid multiplicity of proceedings. It is not a substantive change in the Specific Relief Act from 87 to 63. In spite of all that, if courts continue to hold this, there must be something wrong somewhere. Now, that prayer of mine, this article came out, as I said, in February 2022. I got a call from Justice Anand Venkatesh after a recent speech saying that I've read through your article, I agree with it. I don't know whether I'll get an opportunity to overrule my own judgment. No, he hasn't. He just spoke about it. But then the opportunity came, incidentally, through Justice Ramasubramaniam sitting in the Supreme Court after my article got published in 2022, SEC Online 2096. Though he was a member of that bench, Justice Hemant Gupta and Justice Ramasubramaniam were members of that bench. Manikam versus Vasanta, which went from the Madras High Court, thankfully. And they held this. It's a judgment which has, in my view, now set everything at ease. Now, we don't need to confuse ourselves with whatever I said the last year lecture and this lecture. It's enough if you read Babulal of 82 Supreme Court and Manikam in 2022 Supreme Court. Now, this is what Manikam says in 2022. Para 12. there was no provision in the Specific Relief Act of 1877 corresponding to Section 22 of the new Act. Section 22 of the Act came to be part of the Act in pursuance of the recommendation of the Law Commission in its 9th report submitted on 19th July 1958. The Law Commission was chaired by M.C. Setalvad, had members including S.M. Sikri, G.S. Patak and Nani A. Palkiwala. The Law Commission recommended as under. I'll just read only the important portions. In order to avoid multiplicity of proceedings, the plaintiff may claim a decree for possession in a suit for specific performance, even though, strictly speaking, the right to possession accrues only when the specific performance is decreed. No doubt, it has been laid down since 1877 that possession can be asked for in execution of a decree for specific performance, even though possession was not claimed in the plaint, on the ground that relief for possession is merely incidental to and ancillary to execution of a deed of conveyance. How more clear can it be? And then they say, we think it would be simpler to make a statutory provision enabling the plaintiff to ask for possession in the suit for specific performance itself and empower the court to provide in the decree itself that upon payment of the balance sale consideration, defendant should execute the deed and put the plaintiff in possession, just to avoid multiplicity of proceedings. So this is what 2022, referring to the Law Commission report, has held. And finally they say this: relief of possession is inherent in a decree for specific performance and need not be specifically claimed, but only to clarify the position in law. On the basis of Law Commission recommendation, Section 22 was inserted in the Act. The purpose of introducing Section 22 was a rule of pleading with the purpose to avoid multiplicity of proceedings. Though the right of possession accrues only when the suit for specific relief is decreed, now the court is empowered to provide in the decree itself that upon payment by the plaintiff of the balance consideration within the time given, the defendant shall execute the sale deed and put the plaintiff in possession. And then the court said this, 22 Supreme Court. A perusal of the above judgments, the word above judgments is 1877 to 1950, and Babulal. They quote all those judgments and say, a perusal of the aforesaid judgments would show that relief of possession is ancillary to the main decree for specific performance and need not be specifically claimed. That was the position under the 1877 Act. Section 22 of the new Act was introduced in pursuance of the recommendation of the Law Commission only to avoid multiplicity of proceedings and cut down the delay and not to drive a successful plaintiff to another suit for possession. Though the preponderance of judicial options under the specific opinions, though the preponderance of judicial opinions under the Specific Relief Act of 1877 was in favor of the fact that relief for possession is only ancillary to the decree for specific performance, it was further clarified by introducing Section 22 of the 1963 Act. So, thus, this judgment put an end to all arguments and disputes that a suit for specific performance is not a suit for possession. Whether you ask for possession or not, you are entitled to get for this possession in execution also. And if you're already in possession, you don't need to ask for the possession. So 22 is, in my view, a complete answer to all judgments till now after Babulal. So you should remember only these: 1877 Specific Relief Act, all judgments till 1950, including 27 7 judges Bombay, 29 5 judges Madras, 50 Federal Court 5 judges, were aware of that regime. They all held in personam jurisdiction. And possession is not determinative of the character of the suit. Specific performance is primary object. So now, I would just like to sum up whatever I feel is the correct position of law today. One, insofar as suits for specific performance are concerned of immobile property. Now, what is the law according to me? Referring to all this, the plaintiff in every such suit accepts the title of the defendant. Right? You are not claiming adverse to the title of the defendant. You accept the title of the defendant, but merely ask for transfer of the title by virtue of an agreement in personam. You have entered into an agreement with me. Honor that agreement. I am claiming under you. I am not claiming adverse to you. I am claiming under you. I am not even claiming under you. I am claiming your title. I am wanting to step into your shoes. Please give me that sale deed by honoring your personal commitment to me in the form of a written agreement. One. your right to be put in possession, the plaintiff's right to be put in possession is inherent because of section 55(1)(f) of the Transfer of Property Act. You don't need to ask for possession. The only departure is section 22(2) of the Specific Relief Act of 1963, which says if you don't ask for possession, you will not be given possession till you ask, but you can ask for it at any stage. It's as lucid and as simple as it can be. Now, thirdly, a prayer for specific performance and a prayer for possession by a person under that springs from the same contract. It is not two different contracts. Since it springs from the same contract, one being the primary object, one being the incidental object, they go together. They rise together or fall together. Right? Now, the purchaser's right to possession technically speaking, arises only after execution of the sale deed. But to avoid multiplicity of proceedings, you ask for it in the same plaint or ask for it in the EP. Right. Section 22 is only a rule of procedure. It is not a substantive law. And then the prayer for possession in all such suit is not independent of the suit for main prayer for specific relief. It's only ancillary. Right. Now, lastly, a prayer for possession in such a suit does not alter the nature or character of the suit. It remains a suit for specific relief. So, in all suits for specific performance of a contract for sale of immovable property, with or without a prayer for possession, these are not suit for land based on 82 Supreme Court Babulal, 2002 Supreme Court Manikam, 1950 Federal Court Mulji Jeta. They are all commands by the court to enforce something in personam. Prayer for possession is only incidental or ancillary. But the test there again is your second prayer dependent upon the primary prayer or independent of the primary prayer? If it's independent, it becomes a suit for land. The example which I gave you the other day is Article 65 and 66 of the Limitation Act, where you sue for possession independently. Right. Now, in suits for mortgages, what is the law? Law has been settled now by 7 judges bench Bombay and 2 division bench judgment of the Madras High Court, which says mortgage, you are not seeking to enforce any right qua property. It is only a personal interest, money, not a suit for land. Right? Then such suits are definitely not suits for land. Then the other only confusion which remains is what happens when defendants are all within the jurisdiction of the Madras High Court, Bombay High Court or the Calcutta High Court, as the case may be, where clause 12 of the letters patent apply, but land is outside. Can you seek leave and sue? There are 2 points incidentally which arise, which I want to conclude with. One, where land is outside, but all defendants are inside the jurisdiction. Can such a suit be filed as a suit for land? Can such a suit for land be filed by seeking leave of the court? Suppose the property is in Chengalpet, outside jurisdiction of the Madras High Court. I am here, the plaintiff. Defendants are all the owners of the property here. I am a tenant there also. Even though I am here, I have taken that property also on lease. I am filing a suit for declaration that you cannot, for an injunction that you cannot interfere with my possession there. The moment you ask for possession, it becomes a suit for land because it's an independent prayer. If it's a suit for land, can I maintain that suit here by virtue of the second part of clause 12? What is the second part of clause 12? Now, clause 12 has 2 parts. One, where it is a suit for land, where the land is situated. No ambiguity. Or in all other cases where cause of action arises either fully or in part. Or where if it arises fully, no leave. If it arises in part, leave of the court. Or where defendants reside or carry on business or personally works for gain. So, as I said, there are 2 categories of suits contemplated under clause 12 itself. One category is suit for land. The other category is all other cases. So, if it is a suit for land, you don't have a choice. Land must be here. So, the example which I gave you, protect my possession there, is a suit for land. Land is not here. Suit cannot be maintained in Madras High Court. You have to go to Chengalpet. Because if it is a suit for land, the land must be situated within the precincts of the original side limits of the High Court. There's another confusion which arises. And this is a very legitimate confusion and a very major confusion also. What if land is situated partly in Madras, partly outside? partly within the jurisdiction of the Madras High Court, partly outside. Or suppose there is a partition suit. A partition suit is a suit for land. 100 items of property. 20 items are in Madras, 80 items are in Kanchipuram. Can you maintain a suit here? It's a suit for partition, one prayer. It is a suit for land because division of property. Where can that suit go? Can that fall under suit for land under clause 12 first part, which says where land is situated, you shall file the suit only there. Land is here, land is also there. That is where courts have adopted this concept of forum non-convenience. Now, concept of forum non-convenience is where court looks at convenience of parties. So in this example which I gave you, 80 out of 100 properties, 20 in Madras, 80 in Kanchipuram. The courts have held, there are two division bench judgment of the Madras High Court which have held, majority of the properties outside Madras, leave of the court was initially granted because at the time of granting leave, arguments are not heard from either side. After hearing both parties, we feel the courts in Kanchipuram will be more convenient. Forum, no, the courts in Madras are not convenient. Forum non-convenience to forum convenience, go there. I am revoking the leave here, giving you liberty to file the suit there, even though Madras has jurisdiction too. So when you have a case where property is situated partly within jurisdiction of the three chartered high courts and partly outside, leave comes in. With leave of the court. From 1894, Bombay High Court has held you can file a leave application, obtain leave and file the suit here. But the moment the defendant comes and argues forum non-convenience, we will see which is more convenient. If that is more convenient outside, go outside. If it's more convenient here, but it's all left to the discretion of the court. See, forum convenience or forum non-convenience in the present day it pales into insignificance. The reason why video conferencing is possible, evidence is possible through emails, through whatever. The mode of communication is improved so much, you don't need to physically go to attend any court these days. So that also will weigh in the mind of forum non-convenience court. So when Madras High Court decides today, should you travel to Kanchipuram every day? No. We'll sit here, hold VC. You may come from Delhi, you may come from Bombay or UK. Argue your case through VC. So forum non-convenience or forum convenience, as the case may be, is very different when it was then as it is now post-COVID. Post-COVID, we have taken 10 giant steps forward for mankind. But what remains still is, if it is a case where the defendant comes and says, I'm sorry, it's not convenient for me, even though you have jurisdiction, courts will still decide that. So that is the only, there is only one other issue. Incidentally, there is a judgment of the Supreme Court under the Arbitration Act, where the question of clause 12 of letters patent, suit for land was imported to confer jurisdiction on a court under section 41 of the Arbitration Act. Now, 40 or 41, I don't remember, whichever section of the Arbitration Act talks of jurisdiction of courts. Now, my view is you cannot import the meaning or purport of suit for land under clause 12 of the letters patent, which pertains to suits, to arbitration. For the simple reason that after Balco, arbitration depends upon a lot of things. It is left to the convenience of parties to decide where they want to sit. What is the law of the contract can be different. What is the law of arbitration can be different. What is the curial or procedural law can be different. So, to import clause 12 into arbitration is uncalled for. That is a judgment reported by the Supreme Court, 2021 or 22, I don't remember. Yeah, 2016. Until it is set aside, we are going to use it and to our convenience. But then, the fact of the matter is you cannot import clause 12 of the letters patent, suits for land, into arbitration. Because you have a concept of seat. Seat of arbitration is very important. Seat can be conferred by agreement of parties. I, sitting in Madras, can have a contract with you sitting in Madras where the law is law of England. Both of us can agree to have our seat at Singapore. If we have a seat at Singapore, the Singapore curial law will apply. So to say suit for land, therefore bring it within my jurisdiction is a complete misapplication of the concept of suit for land. So with that, I conclude my lecture just saying that apply your mind, don't read judgments blindly. Apply your mind. See whether it applies to the facts of the case and see whether, two things. One, whether you have a chance of rereading the judgment and coming to a different conclusion. If you can, I am sure no judge in this High Court will think twice about you telling them that this judgment maybe needs to be relooked at. it's nothing wrong. Every person can correct themselves. So today, if one of you come and tell me my lecture is totally wrong, I'll correct myself. I definitely can. But then the fact of the matter is each of you should think for yourself. If we had gone ahead and followed everything, this 2022 Supreme Court would not have come at all. Thanks to 2022 Supreme Court, we are all saved from this drudgery of suit for land. Now, if you read that judgment, everything is clear, right? So, with that, I thank you all for having sat through I've overshot it by 25 minutes. I'm so sorry. So, thank you all, and I only hope and pray that your curiosity is kindled to read more of this so-called very dry subject. All right. Thank you.
Thank you, Partha. Interesting speech, though as you said, it's a somewhat dry subject. But in the course of his speech, the senior repeatedly said by reading the different judgment, he got confused. By reading the judgment, if you are confused, you are a successful lawyer, Partha. Because my senior used to say, by reading the judgment, if you are confused, you are not only popular and successful. If you go to the court with a confused mind, you transfer the confusion to the judges. And eventually, you will get the orders. Because judges don't want to get more confusion. So immediately they will grant orders. Thank you, Partha. Now I pass on.
That's why, incidentally, in any suit for land case, when I go to court, judges say, please don't stand and argue. We know.
Anyhow, thank you all of you for waiting such a long time. It's almost 6:30, but still you're all patiently listening. That shows it's really a mind-boggling speech. Really, I'm very, very happy about it. You all would agree he's a very erudite person. He has exhibited such an erudition. Kindly give him a big hand and applause. So it's a wonderful. I just cannot imagine a person can give in a short span of time so much of so much of judgment, and really enlightened all of us. And also he has given his opinion that I fully endorse his view also. I thank the senior advocate Om Prakash for being with us for such a long time in spite of this busy schedule. Thank you very much, sir. Thank you, President. Thank you, everybody. Please hope to join for more such lectures in the near future. Thank you so much. Bye-bye.